Next case is in re Baby Boy Doe. It's also a 15-minute mini oral argument on the application. Mr. Mansma will start us off and can reserve rebuttal time if that works out. Ms. Speaker will go next, who also may reserve rebuttal time if that works out. Then we'll hear from Ms. Coffrin, and then we'll turn back to the rebuttal, first from Ms. Speaker, then from Mr. Mansma, depending on how it went at the start. So with that, Mr. Mansma, you may begin.
Thank you, Your Honor. May it please the court, Tim Mansma on behalf of Catholic Charities, West Michigan. And if I may, I'd like to try to reserve 3 minutes for rebuttal. This case presents two questions of first impression, one statutory, one constitutional. First, whether a complaint for custody of an unborn child in a divorce case can qualify as a petition for custody of a surrendered newborn under the Safe Delivery of Newborns Act law. Second, whether application of the SDNL to an unknown non-surrendering parent violates the due process clause. The answer to each of those questions is no, and we respectfully ask the court to reverse the Court of Appeals and reinstate the circuit court decision. More than 20 years ago, the legislature enacted the Safe Delivery of Newborns law, joining every state in the union with some form of a safe delivery statute. In doing so, the legislature recognized the numerous competing interests at stake, including those of birth parents, the state, prospective, and actual adoptive families, and the children themselves. And in passing the act, the legislature made a reasoned determination that the safety of newborns should be the preeminent concern, at least in those first 72 hours. And at the same time, the legislature enacted safeguards, guardrails to protect the rights of other interest holders. And it, again, was a reasoned policy determination that the legislature made. The statute has clearly fulfilled its fundamental purpose. In the 20-plus years that the statute has been in place, hundreds of newborns have been safely delivered, placed with adoptive families, when the alternative was abandonment or potentially death. Such was the case here. Baby Boy Doe was placed with the only family he's ever known, his family, when, again, the alternative was potential abandonment or death. He's been living with that family since 2018 until the Court of Appeals reversed the circuit court's determination and placed Doe's status in doubt, and perhaps even more importantly, injected substantial doubt into what is a fairly straightforward statutory scheme. And so again, for that reason, we ask that the circuit court's decision be reversed. If I may begin with the statutory issue, of course, the key provision here is Section 10 of the SDNL, which provides not later than 28 days after notice of surrender of a newborn has been published, an individual claiming to be the non-surrendering parent of that newborn may file a petition with the court for custody. Mr. Kroithoff's divorce complaint in this case was filed before there was a newborn. It was filed before there was a surrender, and logically then, he could not have been a person claiming to be the non-surrendering parent of a surrendered newborn. The Court of Appeals disagreed with that, of course, and ruled that the divorce complaint, which the Safe Delivery Court, of course, didn't know about, was in fact a petition under the Act. And we obviously disagree with that, and I think the legislative history and the statutory text are consistent with Appellant's interpretation of the statute. First, the original statute, as we point out in our brief, applied the same procedure to both a non-surrendering and a surrendering parent. And at that time, the statute used the term biological parent. The trigger under the statute has always been a surrender. That's when the timelines begin to run. And in 2006, the statute was amended to give a non-surrendering parent more time. That is, not later than 28 days after notice of publication of surrender. It was intended to give the non-surrendering parent, because of course they don't always know when a surrender has happened. It was designed to give them more time than the original statute did, but nothing in the amendment or the legislative history suggests that the legislature intended to eliminate the original starting point, which is a surrender of a newborn under the Act. I think it's important, too, to note that there are other provisions in the Act that support the appellant's interpretation. For example, Section 10, subsection 2, which is the consolidation provision. If a surrendering parent surrenders a newborn and the non-surrendering parent wants to file a petition, they can file anywhere that they live, and then the two cases are supposed to be consolidated. That consolidation provision uses the past tense, and it talks about consolidating with the court that issued the placement order. So in other words, the statute contemplates that a surrender has happened and that a placement has occurred. And it's our position that you can't consolidate with a proceeding that doesn't exist already. The Court of Appeals opinion, would also lead to absurd results. If you were able to file a pre-birth, pre-surrender petition under the Act, the statute could not be implemented as it's written because, again, you have things like consolidation. You have things like DNA testing. None of those things, which are required under the Act, could possibly happen if you don't have a newborn and if that newborn hasn't been surrendered. So, again, I believe that the Court of Appeals, frankly, just ignored the language of the statute.
Counsel, I have a question. Does the age matter?
I'm sorry, the age?
The age of the child is 4. Does it matter?
I think it certainly matters, Your Honor, for the family, of course. I don't know that under the language of the statute it does legally matter. But again, it's our position that the divorce petition was not a petition for custody under the Act. And so the circuit court applied the statute as written. Doe was placed, and Mr. Kreutoff's rights were terminated consistent with the SDNL.
I guess my question is like, my concern would be that like here the child is 4. I mean, if I guess my question is, could you have a situation where someone could come when the child's 8, 10, 12? I mean, should there be a cutoff at some point, or how do we look at that?
And I think that's another fundamental problem with the Court of Appeals decision is the court created a remedy that does not exist. It allowed Mr. Kreutoff to come back years after the fact and challenge an SDNL proceeding when his rights had been terminated under the statute years earlier. And I do think that is a problem, Your Honor.
Could that be a concern for a lot of adoptive parents?
It absolutely would be, Your Honor. And this court's case law says time and time again that there is a state interest in finality and expeditious adoptions, and I think the Court of Appeals opinion would call that into question.
Can we get to the constitutional question?
Absolutely, Your Honor. So,
just get to the point. In re Saunders, the court held that due process requires that every parent receive an adjudication hearing before the state can interfere with parental rights. No, and went on to say that the state cannot presume this, cannot presume. So there was no adjudication hearing here. How does this pass constitutional scrutiny?
I don't disagree with that, Your Honor, and I think there's an important distinction between this case and Sanders. All of the cases that we were able to locate that deal with the issue in Sanders deal with one or two factual situations. There's either an established relationship or the parents are known, or sometimes often both. That's the context of Sanders. Sanders, both parents were known. The father had his rights terminated without participating in the proceeding. And of course, this court held that is unconstitutional. You need an adjudication. In this case, however, there is no known parent. Mr. Kreutoff was not known, and that's what the statute contemplates in many cases. And he also didn't have a relationship. And so I think Sanders is distinguishable.
Well, he didn't have a relationship because the child wasn't born. And before the child was born, he filed a divorce petition asking for custody. I mean, what more was this father to do?
Well, I think one thing he could have done, Your Honor, was file a petition under the SDNL. And I know that's an open issue in this case. It's our position he did not do that.
Does not the father have to know that the child's been surrendered before filing a petition?
I don't think it's a requirement, but I think in this case it's important to know he did know. He said in his divorce complaint, which the Court of Appeals did not review, that he knew that the child was likely to be surrendered. And in his divorce case, his lawyer said on the record, she admitted that they had found the notice that was published. So he absolutely had notice in this case.
When did that admission?
That was on
admission
October
occurred?
2nd of 2018, Your Honor.
After the 28-day period?
It was.
And so what are they to do at that point?
Well, I think there were a couple of things that he could have done. Number one, it's not clear from the record, and the record in this case is admittedly a bit unusual because you have 3 different proceedings happening, plus the subsequent request for records, which is now on appeal. I think he could have moved to intervene, which of course he tried to do years later in the Kalamazoo County Circuit Court. He knew about that proceeding, but he didn't do anything. And I think that takes us back to Lair, Your Honor. Lair says, if there's an avenue for you to protect your rights and you don't take it, you can't come back after the fact and challenge the proceedings if the court applied a statute as written.
So what do we do with the fact, though, that you know, in October of 18, you can tell from the transcript on the record that obviously the issue of a safe delivery was noted even, you know, in the filing before the child was born. And in October of 18, they knew that there was a notice. I believe the record shows that he wasn't aware of which court in particular, that the safe delivery court, you know, what court that was until July of 19. But so, and by that point, the timeline had passed, right, to file either a appeal of right or a delayed app from the termination orders or the order of adoption. But there was still time, was there not, to, it was still within a year of his rights being terminated, right? And in fact, it was about, it looked to me to be about 2 months or so that they had all of the pieces, right, that they confirmed their suspicion of safe delivery. They now knew which court it was in and what had happened, and didn't then file for another 3 months, not something to affect the termination or the adoption order necessarily, but to unseal the adoption. So would that year mark, I mean, maybe it would have been unsuccessful, but what are we to take from the fact that he didn't proceed to exercise his, you know, that avenue of relief?
I think that takes us back again to Lair. And if you look at the record in this case, at every step of the way, Mr. Kroitoff had opportunities to protect his rights. And at every step of the way, he did not take advantage of those opportunities. Starting with the fact that he knew there was going to be a safe delivery. He could have filed a petition in any county where he was then residing. He didn't have to know where the safe delivery proceeding was happening. But again, I think under Lair, that inaction, at least in this case, militates against a ruling striking the statute down.
Can you address, was it his obligation, or, I mean, maybe it wasn't a petition for custody under the Safe Delivery of Newborn Act, but it was filed in Ottawa Circuit noting this. I mean, was it, the statute imposes some obligation on the court as well. Is it, you know, the court's fault that it didn't do what was required of it after having had notice of this, or was it his fault, or was it jointly sort of shared?
I don't think the Ottawa County Court is to blame, and I agree with your assessment and reading of the statute. It imposes the obligation on the court. I don't think the Ottawa County Court had an obligation to consolidate or look for a proceeding that didn't exist because it wasn't faced with a petition under the Act. If there are no other questions, I'd like to reserve the balance of my time. Thank you.
Counsel, actually, before you leave, I do have a question for you. I'm wondering, can a complaint of divorce ever satisfy the statute? I know here your issue is it was pre-birth. What if the timing had worked out differently and it was post-birth?
Absolutely. We have never disputed that a complaint can be a petition if it satisfies the statute.
Thank you.
Thank you.
Even in a different county?
Yes.
Okay.
Good morning, Your Honors, and may it please the Court. My name is Lisa Speaker, and I represent the adoptive parents of Baby Boy Doe. Of course, my clients care very much for their child, but they also care that more newborns will be at risk of abandonment or death if this court rules that the safe delivery of newborn law is unconstitutional. The constitutional right of a newborn to live is greater than the rights of a man who may or may not be the biological father. Non-surrendering parent and his amici don't talk about the child's human rights, the child's constitutional rights, or the child's best interest. What more human rights could there possibly be than for the newborn to live? The non-surrendering parent and his amici rely on a marriage to circumvent the rights of the child. And there's a strong likelihood that in this case, the non-surrendering parent is not the biological father. Under the safe delivery law, no man is a presumed father until he comes into court and proves with DNA evidence that he is the biological father. That is what the legislature intended, and that is how that statute reads. The reality is that the Michigan Safe Delivery Newborn Law is most protective of non-surrendering parents of any statute in the entire country. If the Michigan statute cannot pass constitutional muster, then no statute in this country can survive. And the consequence of this court holding that the safe delivery law is unconstitutional is enormous, not just for this child and his family, but for the 21 newborns who are surrendered safely in Michigan every year. Now, this court, we're asking to do three things in vacating the Court of Appeals decision. One, we ask that this court rule that the Court of Appeals cannot reinstate parental rights when the order on appeal before it is not the one terminating parental rights. Two, that the non-surrendering parent's petition for custody in the divorce case did not qualify under the Safe Delivery Act because in this case, he did not request the divorce court to locate the safe delivery case and transfer his custody request to it, even though he knew about the surrender and the statutory scheme. And third, that the Safe Delivery Act is constitutionally adequate to protect the non-surrendering parent's rights. And we also ask in the alternative, if this court, at worst, would remand this case to the Safe Delivery Court for DNA testing, and then if and only if he is the biological father, then conduct the best interest analysis under the Safe Delivery Act as the legislature intended. I'll very briefly discuss the petition for custody because I believe Brother Counsel has gone through it quite extensively. The main thing I want to point out is that the non-surrendering parent could have filed using a SCAO form, readily available, easy to find, an NB case for the petition of custody of a surrendered newborn. And there may have been multiple places on that form where he was going to have to write unknown, and that's okay, because he filed in the right county, because we filed in the right county and he filed in the right county. He filed in the right county because he didn't know where the surrender happened and he didn't know where the mother was. I'm sorry, he didn't know where the surrender was, happened, and he didn't know where the case was. So he had to file in the county where he resided. But in order for a court to be put on notice to go look for that, an MB filing would have been the best mechanism for him to bring that to the court's attention in Ottawa County. Now, the fact that he filed a divorce case, we don't believe is a complete failure, but we also agree that he should have filed it post-birth. But the thing about the divorce case filing is not that he filed the request for custody in the divorce case, it's what he failed to do once he made that request. So in his divorce complaint, he specifically identifies that he expects a safe surrender, and he cites a statutory scheme. He also questions his biology. He does not know whether he's the father, and he demands DNA testing. So he requested the court to enter an ex parte order, which it did. But in his request for ex parte relief, he only asked for DNA testing. He didn't ask for the Ottawa court to locate the safe delivery case or transfer the request to the safe delivery court.
Counsel, let me interrupt you. I'm just curious, as a practical matter, had he made that request or filed the correct, is it a form or a petition, does that work? I mean, does the Ottawa court then find the Kalamazoo case? How does this work in practice?
In the NB, if you were to file an NB case?
Yep.
Yes, because that form, well, he would have had to write into the form, there's a blank spot to
Yeah.
say to locate and transfer.
Yep.
But the rest of the form talks about, it's already out in the form that he has to request DNA testing, because like I said before, any man, every man, anybody who comes into the court who's not the mother who gave birth at a hospital, has to submit to DNA testing.
Yeah.
So that's already on the form. But there is a blank spot where he could write in to locate the case and transfer it. And that would have put the safe delivery, the NB filing on notice to go find it.
And just in practice, then what happens? Like, how do the courts, as you know, we don't have a unified case management system, so.
So the way I envision it, Your Honor, and remember, we only have 21 safe surrenders a year. So even though obviously this is very important for the future of newborns in this state, it's not a lot of cases. So what I envision the courts doing is, one, the clerk's office or the judges can call up, well, first they have to check their own records to make sure there's not an MB case, because he wouldn't know. If it was an Ottawa County, he wouldn't know.
Right.
To check their own files, and then they start contacting local courthouses. And I say local because, it's possible that it could be further away, but why not start with the local counties? And I suggested that you go to the largest county first, near you, Kent County, and then you go to the second largest county, Kalamazoo, and you start making inquiries about whether.
So the Ottawa County clerk just starts calling all the other, this sounds really
And
not great as a matter of process, right?
And it might have to be the judge. I mean, I'm not sure that they would reveal information to a clerk. But the judges, because this case.
But are you aware of any case where that actually happened?
No, Your Honor, because these cases aren't appealed. And so I have worked on the only appeals that have come out of the safe delivery system, and there's one published opinion, the Miller case. So no, I'm not personally aware of any of those cases because they're not being litigated.
Couldn't the safe delivery court have also then searched for an NB case in another jurisdiction?
Well,
They may not have been required to, but like the filing of that, form or case or whatever, I mean, there could have been two courts looking for each other.
Right, so the statute doesn't require that, and so the safe delivery court wasn't on notice, but it's a good hypothetical, Your Honor, and the thing is, with this case, because he didn't file the NB case, even if the safe delivery court had started looking for other NB cases that were filed in the state of Michigan, and I think there is a way to do that, but if you're within the court system. But here's the thing, because he filed it under a DM action, what somebody, whether it's Catholic Charities or the safe delivery court, would have to do is basically physically go to the courthouses and pull up every single, in a certain time period, pull up every single DM case, DC case, DP case, to see and actually read the complaint to see if any of them made mention of a surrender. I mean, that is beyond extraordinary efforts that I don't think we could reasonably expect anybody to do, because there'd be no other way to know that embedded within his complaint, which was like on the third page of his complaint, that he mentions the fact that there's going to be a surrender. I don't know whether I'm the father, but I want DNA testing. And by the way, here's the statute citation as well. So I mean, it's not something that was.
So to that point, so I had asked Mr. Mansma about, can a divorce action filed after the baby is born satisfy the statute?
It could satisfy the statute, Your Honor, if the non-surrendering parent asked for the relief. And I started to answer this question. I think it really ties into your question, Justice Welch. Not only did he not ask for the relief of locating the safe delivery case and transferring it in his ex parte motion, but he was before the court again when he did a show cause motion, because he's pursuing his abused wife to try to get her to submit to DNA testing. And then we know there was an ex parte order issued on September 21st. And we know by that point, they knew when the child was born, what hospital the child was born at, and the date of the surrender. So it's my best speculation that somebody found that publication notice before September 21st, even though we didn't know about it on the record until October 2nd. And he didn't ask for it at the hearing on October 2nd. And that went to another question that the justices asked about, well, what could he have done on October 2nd? Because it was past the time where his rights had been terminated. His rights were terminated on September 28th. Well, he could have done a lot of things. One, he could have then filed a motion for relief in the safe delivery court because it was within 21 days of his surrender. He could have appealed the order of terminating parental rights and then asked the Court of Appeals to remand to develop the record about the petition for custody. He didn't do any of that. And in fact, 13 months went by from the order terminating parental rights until he filed something in the safe delivery court, not asking about his termination, but asking to unseal the adoption records. That was the motion that was before the safe delivery court, and there was no authority to support his request, the Safe Delivery Court denied the request. And then it was 16 months after termination that he did his motion for reconsideration, asking for the first time in his request for relief that his parental rights be reinstated. So there was never an appeal or a proper challenge to the termination of parental rights. And the Court of Appeals decision reinstating parental rights when the order on appeal didn't even have to do with his parental rights, I've never seen anything like it, honestly. It's abhorrent to appellate procedure, but it's also abhorrent to the life of this child. This child has adoptive parents. He's lived with them since he was 2 weeks old. They adopted him over 3 years ago. This child is almost 4 years old, and this child has a constitutional right to the established relationship that he has with his adoptive parents. They are his family. They are his only family. And the thought of disrupting that relationship, and we briefed it, that his rights are superior to those of the non-surrendering parent who sat on his hands and didn't do enough to find the safe delivery case. The adoptive parents also have constitutional rights. They are treated as if they're the biological parents once the adoption happened. Sister counsel said in her brief that their rights are statutory and therefore lesser than the non-surrendering parents. Well, their rights to adopt did come from statute, but that's where their rights begin. That's not where their right ends. Their rights continue, and they're treated as the natural parents. Laird versus Robinson, even Smith versus the Organization of Foster Families, all talk about that established relationship with the family that raises you. And again, here, we don't even know if there's a biological connection with the non-surrendering parent, but that doesn't even matter because the rights to that established familial relationship is higher than the rights the non-surrendering parent has, who comes into the game very late. I did want to point out the distinction between the Smith versus Organization of Foster Families and a lot of other cases that recognized that some people don't have constitutional rights. And we agree with that. A foster family has a contract with the state. They don't have constitutional rights. Prospective adoptive parents don't have constitutional rights in the temporary placement. Guardians don't have constitutional rights, and this court just had a discussion about that in the Verzali case. But they don't have a constitutional right above a parent who's been raising their child. And third-party custodians don't have a constitutional right either. But we don't have any of those players here. We have adoptive parents who adopted this child over 3 years ago, and not only did that, but they have an established relationship with this child for almost 4 years. And I don't want to lose my rebuttal, so I'm going to sit down. Thank you.
Good morning. May it please the court, Serafina Confran. I'm here with co-counsel Mike Villar and John Moritz. There is a lot of discussion about the notice provisions within the SDNL, which is detailed in, 250 pages of briefing that are highly problematic. Before I get to that, what is just as concerning is what comes next. And I'm addressing this because I'm aware of the order denying leave in Ray Versale, where the court very specifically stated that for a facial challenge, we must establish that no set of circumstances exist under which this act could be valid, citing the League of Women's Voters. So it's our position. There is no set of circumstances where the SDNL as a whole exists where it is valid. Why? Because even if a parent somehow, hypothetically, say we have a parent who lives in the county, gives birth in the county, and the SDNL case is in that same county, okay? Say it's a real easy case, and the publisher's in the county. Say the parent finds that publication, sees it. What information is going to be in there? Because the adoption agency is strictly prohibited under penalty of criminality, a misdemeanor fine or imprisonment, from releasing any information at all about their case file, about the confidential sealed records. So if Peter Kroidov had seen that on day one, if he had called that 877 number, are we really under this legal fiction that Catholic Charities, the same Catholic Charities who fought for 7 months where they couldn't find the child, maybe it's in Kent, maybe it's, who knows, all that. Are we really to believe that they are going to defy the confidentiality provision and say, oh, hello, random person calling from a newspaper classified notice? Yes, let me tell you about all the babies we have, let's
Well,
see.
but is that really what the remedy is and what makes it constitutionally infirm, right? Had that happened and they've been notified by somebody who had the notice and within the time, the agency then has a report, right, to give to the surrendering court that would identify a non-surrendering parent who is challenging custody. Like, right? I mean, isn't that, maybe they wouldn't tell the random person who calls answering a newspaper ad anything about it. But the act then puts a requirement on the agency to inform the court of the existence of a non-surrendering parent who is challenging custody.
So the statute does not require the agency to notify the court of every single phone call it receives.
But does it,
But
but
it
what about
wasn't-
every single
yeah.
petition it receives?
Right, they're not notifying of a phone call. It's a very specific claim of being a non-surrendering parent who is challenging custody.
If a non-surrendering parent were to receive that, or notice the notice in the newspaper and call the ad, there is no nexus between, there is a gap in between what the agency can tell them for them to file a petition. If they filled out the scale form with virtually no information, they still might not know where to file that form.
But if they file it in Ottawa Circuit, then Ottawa Circuit has to figure out what to do with it, right? Isn't that enough? I mean, if your client had filed a petition under the SDNL, wouldn't that be enough? It doesn't matter where he files it.
And that is, I suppose, one of the things that boggles my mind about Catholic Charities' argument in this case, that they say repeatedly, if you would have filed that scale form on day one of birth, or, if he would have filed that scale form, he would have been guaranteed an ability to conduct.
And that's not true?
How can it be true? The practical reality is if he had filed, and again, we're talking about if in any situation, if the Ottawa County Court started its search and didn't find the other court in 28 days, they're arguing there's no legal remedy. But hypothetically, even if they did file that NB form or a complaint for divorce, and even if they did have that proceeding and they're able to appear in the SDNL case, we have an even bigger elephant in the room that what happens next is a best interest hearing. There's no appointed counsel. There's no requirement for an LGAL for the child. It is a best interests analysis with no adjudication of unfitness. Absolutely nothing about unfitness. It just goes in the statute straight to, you file a petition for custody, you get a best interest analysis after the DNA testing. After the DNA testing, best interest analysis. And inside that, even though there's no unfitness adjudication, there's no parental presumption, which specific in the Child Custody Act, which yes, is kind of held in abeyance by the SDNL. 722.25 is a specific statutory parental presumption. In re Versailles, the 52042B guardianship code, this court just said last week that that's a general inferred presumption. Here, we don't have a specific parental presumption. We don't have anything about intent to leave a child forever with another person. We're talking about the non-surrendering parent here.
These
We
are
have
all
nothing.
issues, though, that aren't implicated in this case.
But they are implicated.
Well, but I mean, how would we, there was no best interest determination, and so us balancing you know, whether or not the presumption of parental fitness is, you know, how that gels with that. I mean, I understand in the general sense that the constitutionality in general of the statute, I guess, is at issue, of the whole statutory scheme. But I guess focusing on this particular case, and if we had an instance where we could actually evaluate how that was done, not instead of sort of dealing with these hypotheticals of how things would work and all that. We have facts in the case that I think at best, your client was aware of all of the pieces that were necessary, arguably earlier, but let's give him until July of 19. Knows where the court, you know, where this is all happening. The 1 year mark to challenge the termination of his parental rights has not passed. Why isn't that a problem for him? Why he hasn't challenged the termination or the adoption order?
Well, I don't know where the 1 year mark for challenging his termination, unless we're talking about the court rule fix of the 2.612 for setting aside an order general. But first, you would have to be a party, and first you would have to intervene. And say he did intervene as a party, which they tried to do and were thwarted. But even if they tried to intervene as a party, that takes time. In reality, you cannot just file something in the court, in a trial court, and get a hearing the next day. You're talking about weeks, months, before you even get hearings on these matters.
Well,
And
your
even if-
client filed something in Ottawa Circuit and got something within like a day or two, right? That awarded custody of a as yet unborn child.
An ex parte order.
So, I mean,
Yeah.
it's possible, right? I mean, there are 2 months and then there's 3 months since he had all the pieces, you know, before filing a motion to unseal an adoption. And I think there had obviously been other filings going on, you know, directed towards a surrendering parent, perhaps directed towards a different action against Catholic Charities. I mean, there's no lack of filings, but not a filing challenging the termination order that affects his rights as a you know, non-surrendering parent who's challenging the custody of this child.
Well, anytime that I've initiated an appeal, you need to have transcripts of the hearing, you need to have a copy of the termination order, you need to be able to say what went on in order to legitimately, the court rules require at 1.109, we are required to have a legal and factual basis for our claim. If he were to say, I don't have any of the records, I know the case number in the county, what is he going to put in his appeal if he doesn't have those records? He needs those records so that he can then do the next step. We can't just expect parents, we can't place, and it goes back to this idea that we need to place the burden of locating, or the burden of telling the court clerk's office, this is what you need to do, to place that burden on the non-surrendering or the surrendering parent. We're talking about parents who are, as oft repeated by brother and sister counsel, in distress, which I know we are not talking yet about a best interest analysis, but that is what is around the corner for Peter Croydov. That is around. He's going to go back to the Kalamazoo court, and the Kalamazoo court, if this court denies leave, and we are actually asking that if this court were to deny leave, that in its order denying leave, still be explicit. We don't have to say, we don't have to ask you rulings on the SDNL about whether the lack of a parental presumption is constitutional or unconstitutional, or whether it's stricken or not, but just reiterating that the SDNL, it contains that provision that suspends the adoption code, it suspends the juvenile code, it suspends the Child Custody Act. It cannot suspend the Constitution.
Counsel, I'm curious, there was a lot of talk in the briefing about, obviously, all states have some version of this law. Michigan apparently has more generous provisions for, the putative father's rights than many states. We have the Supreme Court's decision in Lair weighing in sort of on these concerns. Why aren't we just bound by Lair? and what, you know, that essentially that these provisions are constitutional, that there is enough notice.
The difference being is that Peter Croydoff is not a putative father. Lair, essentially, as we all know, because it's all that hundreds of pages have been talking about is Lair, is that does the state statute give the father an element of control? In Lair, he didn't mail in the postcard. Here, Peter Croydoff, any married man, the putative father registry is for putative fathers. The notice of intent to claim paternity, which, by the way, the statute uses the word child if in the notice of intent, if when the woman is pregnant, you wish, and I could probably flip to the actual statutory language here, that also uses the word child and referring to if you want to claim paternity of a child during pregnancy. Same thing, you know, the notice of intent, that is strictly for unwed, out of wedlock children. The Paternity Act, where if a father seeks to initiate, they can initiate a paternity act during the pregnancy of the mother regarding paternity of the child. There it is again, child, during
Counsel,
pregnancy, child.
I have a question.
Yes.
Well, I mean, this is a very difficult case. What are the implications for adoptive families?
The implication for adoptive families is that they need to make sure that everything was done correctly before proceeding with an adoption. We were not asked on the supplemental briefing to address whether or not the adoption here is, or adoptions in SDNL are void ab initio to begin with, because the legislature apparently overlooked in the nexus between the SDNL and the adoption code, because the adoption code contains specific areas where the court has jurisdiction over children, direct placement, agency, and from the state, like from the court. Direct placement, obviously, we're not talking about, but for an agency, for the court to have jurisdiction over an agency adoption, the statute under the adoption code specifically states if the parental rights have been terminated pursuant to 12A. There is no mention of Section 12.
And counsel, I just have a question. I mean, I know this is a ways down the road, but what is in the best interest in this situation? What is in the best interest for this child?
The best interest for this child is to have his constitutional rights, which are presumably, per the U.S. Supreme Court and this court, presumably aligned with his father until such time as there is an adjudication. There is a legal presumption. Sure, we can rebut it with some evidence, which is lacking here, but there is a presumption that this child's constitutional rights are aligned with Peter Croydoff. We have no provision in the SDNL, contrary to their assumptions, that says that the SDNL somehow divests the divorce court of the jurisdiction from the divorce code. There's nothing saying that the SDNL, nothing within the SDNL that says that the SDNL takes precedence over the divorce code presumption. We have two competing statutes. This court regularly tries to read everything in pari materia. I understand the issue of the best interest, and I think that the only thin silver lining to this black cloud of a case of procedural errors is that this child is 3, not quite 4.
Thank you.
I don't have memories from before I was 4. We are concerned about this child, God willing, if he lives until he's 80, that he will be able to have the next 76 or so years of his life with his biological presumptive family. Thank you.
Thank you, counsel.
I have a lot to respond to, but I'm going to have to try to pick the top couple items. First of all, the child does not have a constitutional right, as non-surrendering parent says, to be raised by a biological parent. That is not what the cases say. In fact, it's the opposite. It talks about a parent's constitutional right to raise their biological child unless the court finds them to be unfit. We don't know if the non-surrendering parent is a biological father, and we won't know We may never know, but unless it goes back to the safe delivery court for the DNA testing.
So do we just ignore the presumption that this is a child of the marriage?
Yes, Your Honor, because the legislature in enacting the Safe Delivery Act explicitly said, that any man that comes into court requesting custody has to prove with DNA evidence that he is a biological father before he can assert any rights. And to address your question and Sister Counsel's comments, when the legislature enacted the Safe Delivery Act, it came after the divorce statutes, it came after the Child Custody Act, it came after all of these other acts. And it's a very specific, narrow statute about a child surrendered within 3 days of birth, which trumps the general provision in the divorce statutes that do give a presumption of fatherhood in the divorce statutes. And that comes from the common law, but you know what? The legislature knew about that. It knew about the divorce statute presumption, and it knew about the common law when it enacted the Safe Delivery Act in 2001. And it explicitly stated that any man that comes to court has to prove with biology that he's related to this child in order to have any say in what happens to the child. So that is constitutional, and the legislature knew what it was doing. But regarding the fitness issue, the Hunter v. Hunter case that this court decided in 2009 talks about how even when fitness is not part of the statutory analysis, it's still an intrinsic component of the trial court's evaluation because it's embedded into the best interest factors. So if the trial court were to ever have to get to a best interest analysis in some safe delivery case, the fitness is subsumed within that analysis of the best interest. Thank you.
Thank you, counsel.
Thank you, and I'm going to try to be brief with the limited time I have. Justice Welch, I think you asked a question that encapsulates where we are on the constitutional issue, and you asked why aren't we just bound by Lair? And I think we are, and I think that requires that the Court of Appeals decision be reversed and that the SDNL be upheld. Mr. Kreutoff, of course, is making a facial challenge to the statute now. He didn't make that challenge at any point prior to this court's order. And there, of course, is a presumption of constitutionality that the court should keep in mind, and that it has emphasized in its opinions. But I think the hypothetical that counsel presented proves that a facial challenge must fail. The hypothetical is what happens if Mr. Kreutoff calls Catholic Charities and says, I'm the father. And he certainly could have done that. The notice had Catholic Charities adoption division's number there. Under Section 7 of the statute, Catholic Charities would have been required to give him notice of the Kalamazoo County Circuit Court proceedings, and he would have been in an even better position than he otherwise was. He didn't do that, and for that reason, I think his rights were properly terminated. If there are any questions, I'm happy to answer them. Otherwise, I'll rest on the briefs.
Thank you, counsel. Thank you all. The case will be submitted.